Welcome to The Explainer. Today, we're diving into a massive, high-stakes battle. It's about a company's right to protect its invention versus a country's duty to protect its citizens. This is a story about patents, patience, and a fight that went all the way to the top.
So, let's get right to it. Can a country just legally copy a patented medicine? Well, there was this fascinating legal battle in the Philippines that puts this exact question to the test. And trust me, it's a total David versus Goliath story, but set in the world of big pharma.
All right, so our story kicks off with two companies, one really valuable patent for an anti-ulcer drug, and a legal showdown that would end up in the Supreme Court. Okay, so in one corner, you've got Kline French Laboratories. This is a huge global pharmaceutical company from England, and they hold the patent. And in the other corner, we've got Doctrines Pharmaceuticals, a local Filipino company that wanted to make a more affordable version of that same exact medicine for their own people.
Now, you might be wondering, how could a small, local company even think about challenging a global patent like that? Well, the answer is in this really powerful and pretty controversial legal tool that's designed for exactly this kind of situation.
And here it is, the key to this whole story, compulsory licensing. What is that? It's basically the government stepping in and saying, hey, your patent is totally valid, but for the public good, we are going to let someone else make your product. And don't worry, you'll get paid a royalty for it. This single idea is what the entire fight is about.
So under Philippine law back then, you could apply for one of these licenses just 2 years after a patent was granted. And yeah, there are a few reasons you could do it, but here's the kicker. The most powerful one is specifically for inventions related to medicine. The goal is pretty obvious, right? To stop anyone from having a monopoly on life-saving drugs.
As you can probably guess, Kline wasn't just going to roll over and accept this. I mean, they were facing the loss of their exclusive monopoly in the whole country. So they launched this massive, multi-front legal attack to stop that license in its tracks.
Okay, first up, they went international. They argued that forcing them to share their patent was a violation of major global agreements, like the Paris Convention, which is this huge treaty designed to protect patents across borders.
Next, they attacked the government's own authority. They basically said this was an invalid use of what's called police power. They argued that, hey, you haven't even proven there's some huge public health crisis that would justify taking such a drastic step.
Then, of course, they argued about the money. The royalty they were offered was just 2.5% of net sales. Kline basically said, that number is so ridiculously low, it's like the government is just taking our private property without paying us what it's worth.
And finally, as you see so often in these big legal fights, they tried to win on a technicality. They claimed that a required public notice was never filed correctly, and because of that, the entire case should just be thrown out.
So there you have it, 4 major arguments: international law, constitutional rights, money, and a procedural error. Now let's get to the good part, how the Philippine Supreme Court actually responded. Well, the court's decision was about as clear as it gets. Petition denied. They sided completely with the local company. The compulsory license was a go, and Doctors Pharmaceuticals got the green light to start making the drug.
And the court just systematically tore down every single one of Kline's arguments. On international law, the court said, actually, the Paris Convention allows for licenses like this to prevent monopolies. Police power? Protecting public health is one of the core things a state is supposed to do. The money? The court found the rate was totally reasonable. And that little procedural error? Sorry, you waited way too long to bring that up. Game over.
So let's focus on this number for a second, because it's so important. 2.5%. The court said, yep, this is the right number for the royalty, based on the net sales of the drug that Doctors Pharmaceuticals was about to make.
So how did they land on that number? Well, the court's logic was pretty simple. It pointed out that the local company was only getting the bare right to use the chemical compound. Kline wasn't giving them any secret formula, any technical help, nothing. So for just the right to make the drug locally, the court said 2.5% was perfectly fair.
So, this one case from the Philippines perfectly zooms us out to a huge, fundamental global debate that is honestly more relevant today than ever before.
And here's the core tension, right? It's about rewarding innovation versus ensuring access. On one hand, you absolutely need patents. They give companies that temporary monopoly so they can make back the insane amounts of money they spend on research. Without them, we might not get any new drugs at all. But on the other hand, governments have this profound duty to protect public health and make sure people can actually get the medicines they need to live.
You can see how the law here really tries to walk this incredibly fine line. First, it gives the patent holder a 2-year exclusive monopoly to get their product out there. But after that, it opens the door for these compulsory licenses, all in the name of public health. And it still makes sure the original inventor gets paid. It's this very structured attempt to balance both of these crucial needs.
So at the end of the day, this whole story isn't just about one drug in one country. It leaves all of us with this critical, ongoing question that every single society has to answer for itself. In a world that runs on patented innovation, how do we design our rules to make sure the rewards of that innovation benefit everyone and not just the people who can afford to pay the price?